Welcome to another episode of the Lincoln Commission on Human Rights show, We All Have Rights. My name is Francisca. I am the Community Outreach Coordinator for the City of Lincoln, and I work with the Lincoln Commission on Human Rights. Our office investigates allegations of discrimination for employment, housing, and public accommodations for the City of Lincoln. We also provide training and education about civil rights laws and relevant topics. As most of you are probably aware, that the Lincoln Commission on Human Rights annually hosts a civil rights conference in April. Due to the pandemic, we canceled this year's conference, but it will be held hopefully next year on April 21st. We hold it every April because April is Fair Housing Month. When the conference was started, it focused solely on housing issues and discrimination. While we have expanded our conference to include employment discrimination and related issues, we keep it in April to commemorate the enactment of the Federal Fair Housing Act on April 11, 1968. Today joining us will be Margie Nichols. She is one of our senior civil rights investigators, and Margie serves in a neutral capacity investigating discrimination complaints filed in her office. She also provides training and education in discrimination laws. So Margie, welcome today.
Thank you, Francisca, and thank you for having me on the show. As Francisca said, I investigate discrimination complaints for those living and working in Lincoln who allege that they've been discriminated against or singled out and treated differently based on a protected class. Those protected classes include race, color, sex, national origin, marital status, religion, disability, age in employment, familial status in housing, and retaliation. You can learn more about those protected classes at our website located at humanrights.lincoln.ne.gov, and you'll see it at the end of the show. As Francisca said, April is Fair Housing Month. Each year, the United States Department of Housing and Urban Development, or as we call them, HUD, designates a specific theme for April. This year, the theme is Call HUD, because sexual harassment in housing is illegal. Of course, our office would say call LCHR, call us, because sexual harassment in housing is illegal. Our office contracts with HUD to investigate allegations of housing discrimination occurring in Lincoln, which includes sexual harassment. Anyone who believes they're being or have been sexually harassed as it relates to their housing should contact us.
Thank you, Margie, for that information. And as she stated, a lot of that information will be at the end of our show with the contact information. So even though the theme of about sexual harassment, has the current COVID-19 pandemic caused any housing issues to surface?
That's a good question. While HUD hasn't provided any specific numbers or actual complaints filed, HUD Assistant Secretary for the Fair Housing and Equal Opportunity, Ana Maria Farias, did report that HUD personnel have received reports of individuals alleging being denied housing because of COVID-19 fears. HUD is tracking complaints received because of the coronavirus and has actually added COVID-19 to the federal database that we use when we file housing discrimination complaints so they can track it.
Thank you. Even though HUD hasn't provided many details of those alleged denials, what kind of housing discrimination could be related to COVID-19?
Good question. There are two protected classes that come to mind right away: national origin and disability. For national origin, that means denying rental to a prospective tenant or taking an adverse action, such as evictions, against a current tenant because of his or her national origin. For COVID-19, that means an unrealistic fear or belief that someone who is Chinese or appears to be Chinese or Asian is somehow to blame for the virus or has the virus.
Wow, it's incredible that in this day and age, we would still see those types of cases. But because Is that because of the first cases of coronavirus reportedly came from China?
Exactly. However, based on that, then the same fear could be connected to any national origin when there are a lot of positive cases, unfortunately, and deaths, like in Italy, which has
Right.
had more confirmed cases now and deaths than China, or now, unfortunately, for us, anyone whose national origin is American. That does not mean someone who is of Italian national origin is more likely to have the virus than, say, anyone born and raised here in the United States.
That is interesting information. You also mentioned disability, though. How is that connected to all of this?
Yes, even though COVID 19 has not been diagnosed or designated as an actual disability, because we just don't know enough about it, we
Hmm.
know that people with existing disabilities are more likely to be severely affected if they contract COVID 19. So let's say a housing provider sees or hears about a tenant who has the symptoms of a COVID 19, coughing or sore throat, fever, chills, and shortness of breath. Based on that, the housing provider decides to begin the eviction process against the tenant because he or she fears it could be spread throughout the apartment complex. Taking that kind of action could be discrimination based on regarding the individual as being disabled.
So, what does that mean, being regarded as disabled? How does that differ from actually having a disability like diabetes?
Under the Federal Fair Housing Act, disability is defined the same way it is by the Americans with Disabilities Act. However, for housing, everything is under the Fair Housing Act.
Mhm.
However, disability has a three-pronged definition. The first part of it is an individual who has a physical or mental impairment that substantially limits one or more major life activities, like diabetes.
So, is that commonly understood definition of disability? Isn't it?
Yes, that's how we most know or think about disability. Someone who actually has a physical or a mental impairment that substantially limits major life activity. However, disability actually has two other definitions. The second one is an individual with a record of a physical or mental impairment. This includes someone, say, for example, who has recovered from or is in remission from cancer.
Mhm.
However, it's the third definition that I was referring to earlier in the example. Someone who is perceived by another as an individual with a physical or mental impairment. They don't actually have the disability, but the other person or individual perceives or believes that they do.
Okay. That is a lot of information again, but it's important that we all know the difference. So, does that mean that the person may not have a disability, but the housing provider believes that they are or treats them as if they are disabled?
Exactly. And it's really good to keep kind of referring or repeating that fact that that definition does just mean that the housing provider would believe or perceive that they are disabled. And they have to make sure to take care, the housing provider, to not take adverse actions against a tenant based on fear or perception someone might have COVID 19.
Thank you. That I think is a very important statement because I think a lot of the people, as we have been talking about, really don't know what their rights are or what the definition is. So the fact that you've touched on that is great. But what can a housing provider do if they learn that a tenant may have symptoms or actually is diagnosed with COVID-19?
First and most importantly, they shouldn't make any assumptions. A housing provider has no right to question the tenant, like asking if they have COVID 19. However, they can certainly be proactive, like getting the word out to all tenants about what symptoms they should watch out for and what to do if they have symptoms. such as contacting their primary care physician if they have one, and the Lincoln Health Department. Housing providers can provide contact numbers for tenants and current state or federal guidelines. Give those to them, such as the staying at home and wearing a mask right now, really important if the tenant must go out.
So, a little follow-up question to what you just stated, which I think is very important. Can a landlord um, give the name of that tenant to everybody else in a building that might be positive with COVID-19?
No, you're talking still again having to do, that if they're perceiving that someone, has COVID-19,
Mhm.
maybe related like to a disability or whatever the reason, privacy still comes into play and HIPAA, and they have no right to do something like that. Any information, if they were to find that out, should be kept confidential. At the same time, if they were to find out that they do have a tenant who has COVID-19, then certainly, because working in tandem, and we'll talk about this a little further ahead,
Mhm.
with the health department, to relay that information to whomever they might have contact with, again not identifying who the person is,
Right.
and also going the extra measure effort to make sure that any common areas are sanitized, so that they're protecting all tenants.
Okay. Okay. Thank you for that. But what if a tenant does have symptoms or test positive for COVID-19 and is self-quarantined at home?
Yeah, again, for the tenant, of course, if they believe they have COVID-19, they should be contacting their primary care physician if they have one. And if they don't, contact the health department. The decision to test would be made according to the most current CDC guidance. And if testing is done and it comes back positive, and there is a possibility of community spread, a list of places where that individual has visited or have been would be created, such as, like we were talking about, the apartment complex where they live. And say that they do use like a community washer and dryer. The
Hmm.
apartment complex would be contacted about a potential virus connection. Then the
Hmm.
bottom line is that housing providers should not decide to act on their own without directional guidance from the health department. Their best practice would be to work with the agency who contacts them.
Very well. So we have listed the contact information for the health department, but what if a tenant tells his or her housing provider that they have COVID-19 and then asks them not to evict them because they can't work?
Now, if a tenant decides to tell the housing provider on his or her own, the housing provider can ask how the tenant knows they have it, since they are not asking not to be evicted because they can't pay rent. Reasonable questions include: has that person been tested, or how do they know they have COVID-19? The housing provider could probably also ask if the person has contacted his or her PCP and or the health department. As it relates to the job, the housing provider should find out why the person can't pay rent. Were they laid off or sent home because they were symptomatic? Or were they discharged due to the lack of work because of COVID 19's devastating effect on so many of our businesses and employees? There needs to be an open and continuing dialogue between the housing provider and the tenant.
Right, that is important, keeping that dialogue open. But for our purposes, when it comes to discrimination, we would want to know if someone believes they were being evicted because of their national origin or being regarded as disabled.
Yes, it's very important to note that we don't handle tenant landlord law. So if the threat of eviction is because of losing their job or being laid off because of the coronavirus and not because of discrimination, we would provide resources to the tenant, but we have no authority in those situations. Currently, housing providers have been asked not to evict people if they can't pay rent because of COVID-19. Again, being laid off or losing their job due to the pandemic. Also, again, the governor has recently issued an executive order giving tenants affected by COVID-19 certain protections.
Yes, and those are important. It is important for people to know what resources and what rights they have. So you mentioned resources. That includes NEVA, who is the tenant landlord specialist at the Lincoln Community Action Partnership, and Legal Aid of Nebraska. Those numbers are listed. Also, the Fair Housing Center of Nebraska and Iowa has the ability to act as an advocate for tenants, correct?
Yes, they can. Whereas the LCHR is a neutral agency, so we cannot act as advocates or on the behalf of tenants or housing providers. Contacting someone like the Fair Housing Center of Nebraska and Iowa, they can act as an advocate for someone who believes they're being discriminated against. And again, getting a hold of NEVA as the tenant landlord who is the tenant landlord specialist at Lincoln Action Community Partnership, or contacting legal aid, that would be the best bet. And unless you're talking about discrimination based on one of the protected classes, as we said before, like national origin or disability.
Okay. So before we end, I want to return briefly to April's fair housing theme about sexual harassment. What type of sexual harassment happens in housing?
That's a good question. And basically, there are two types. One is called quid pro quo, which simply means this for that. Examples include when a housing provider offers to reduce a tenant's rent or promises not to evict them in exchange for the tenant providing some type of sexual favor. The other type is hostile environment sexual harassment, or when a housing provider subjects a tenant to severe and pervasive, unwelcome sexual conduct that interferes with that person's rental, the availability or privileges of housing or housing related service, basically any part of the rental process. Examples of hostile environment sexual harassment include unwelcome touching, like kissing or even making lewd comments.
Thank you, Margie, for joining us today to talk about Fair Housing Month and housing issues related to the pandemic.
Thanks, Francisca. It's been a pleasure to be here.
Thank you very much. The information that you gave us is very essential to what is going on during this time that we are all at home working, teleworking. For additional questions about fair housing as it relates to COVID-19 or anything else related to fair housing rights, please call us at 402-441-7624 or send us an email at lchr@lincoln.ne.gov. Thank you for joining us today. As a reminder, our office also provides training and education regarding anti-discrimination at no charge. If your agency is interested in learning more about this, please contact us. And remember, we all have rights.